No part of this lecture material may be used without the express written permission of Rick Ramos or Contra Costa College. This is Professor Rick Ramos, and this is a continuing lecture series on criminal procedures. Today's lecture, Lecture 8, Part 1, Trial Procedures. I'm going to start off by talking about the person who's in charge, which is the magistrate, the judge. Sometimes the judge is also referred to as the court. And they have three methods of selection. They could be appointed by the governor, or a committee can submit three names to the governor, and at that point the governor will appoint the person. They can always run for election. It could be a nonpartisan election, meaning that they don't necessarily tie themselves to the Democratic or Republican Party or Green Party or whatever. Or it could be a partisan election where they do tie themselves. And the last way is a hybrid. This is where they're appointed and then they run for office after that. And it's important to note that judges can change because as the public changes, they may pick someone else that they want to be the judge. Judges or magistrates have a huge responsibility because they have to deal with both the prosecution, defense, and answer questions, legal questions like requests for change of trial time or place. They know that they have the Sixth Amendment looming over their head with a guarantee of a speedy trial, so they have to rule on continuances. Now, continuances are requests to extend the time before the trial will start so that you could find a witness or have evidence processed or whatever. And there's a case called Barker versus Wango. What that talks about it, there was not a violation of a speedy trial guarantee if the defendant requests continuances and then at some point the prosecution needs continuances also, that it shows that and that case basically states as long as everything's done in good faith with the intention to get through the trial, that it doesn't have to be at the whim of the defendant when that trial will end or start back up. There is a very interesting case called Smith versus Huey, and this is 1969. This guy is in custody in Texas on a separate charge. He's doing time and he knows he has a burglary charge back in California. And so he requests to be sent to California so he can have his trial because he feels that he may be able to serve his time concurrently. In other words, he could serve time in Texas and it counts in both California and Texas. And it is possible. And the court denied that. And so what he did was he took it all the way to the Supreme Court and they said, no, you have to, even if he's in custody serving time, you know where he is, you have to prosecute him on this case. Now, California regulations pertaining to a speedy trial. On misdemeanors, if the suspect is in custody, or at that point the defendant, then the trial must begin within 30 days. So in custody, misdemeanors, 30 days. If not confined, if they're out on bail, 45 days. On felonies, there's kind of a sliding scale. The defendant has a right to trial between 5 and 60 days after indictment or information in the Superior Court. As the trial begins, the judge's responsibilities include overseeing the jury selection, ruling on evidence and other aspects of an adversarial procedure, instructing the jury as to the legal rules affecting the case, charging the jury and receiving a report of their findings of deliberation. And if it's a non-jury trial, if it's what we call a bench trial or a court trial, then there's no jury and the judge actually makes a decision involving guilt or innocence. Now, how are juries selected? Well, what happens is they have a list that's made up from a variety of different sources, including the voters' registration, hunters' licenses, and driver's licenses, and a jury pool is developed. A computer then randomly picks the prospective jurors and issues a subpoena and sends it to their home. There's been a lot of controversy over jury size. 12 is a standard in California, but other states have gone with less than 12. In Florida, New York, Virginia, and Georgia, for instance, they use less than 12. Florida's been using 6 for a long time. 1970, Williams versus Florida was the first case where the Supreme Court said that 12 were not needed. And I believe in that case what happened was there were 12 jurors and one got sick and 11 found him guilty. And the court said that was fine. In Ballou versus Georgia in 1978, though, the Supreme Court said that you had to have 6 as a minimum to make a decision on guilt or innocence. That 6 and 5, there wasn't much of a difference, but the line had to be drawn somewhere. In Contra Costa County, what happens is a digital badge with a barcode comes to your home with your name on it and a summons to appear. If you fail to appear, a judge could issue a warrant for your arrest. You put the badge on at the courthouse, they barcode read you, and they send you to the room that you need to go to. A computer then randomly selects the jurors and sends them to different courtrooms where the judges put them through what's called the voir dire process. Voir dire means to examine you. Okay, that's a French term, I believe. Process of questioning prospective jurors by the prosecution and defense to screen out persons who might be biased or incapable of rendering a fair verdict. This is conducted by the judge, so the judge will have a list of questions. Nowadays, they also do pre-screening questionnaires where you're required to fill out an application, and the defense and the prosecution will use that application to challenge your ability to sit on the jury. If the defense or prosecution feels that you are biased or for some other factor you being able to make a fair decision, they could challenge you for cause, and the judge makes a decision as to whether or not they'll accept the challenge and excuse you as a juror. There is also what's called a peremptory challenge, and this is the ability to remove a prospective juror by the prosecution and defense without providing specific reasons. In cases, different states have different requirements in this area, one being that they allow 8 to 10 preemptory challenges depending on what state you're in. Another thing that can happen is the judge can actually be requested to change the venue, and when they're looking for jury, if they find that all the people in the pool have some knowledge of the case because of media exposure, whatever, they might ask for a change of venue. The purpose of the trial is to judge the defendant on the facts of trial, not the media events, so a judge would have to consider that change of venue to another location where there wasn't so much publicity. Again, I want to talk about court trial versus jury trial. Make sure you understand these two concepts. In a court trial, the judge deals with legal questions and procedures in the courtroom and also renders the verdict regarding guilt or innocence. In a jury trial, the judge deals with the legal questions and procedures in the courtroom, and the jury renders the verdict regarding guilt or innocence. And that's the basic difference between the two. Now, when they talk about double jeopardy, remember it says in the Constitution that you can't be tried twice for the same crime. That concept is called double jeopardy. And when does jeopardy attach? Well, in a court trial, when the judge swears in the first witness, that begins the concept of jeopardy, the first jeopardy. In a jury trial, jeopardy attaches once the jury is sworn. Attachment of jeopardy basically means that the defendant has been placed in a position where they could be convicted or subjected to a punishment. Now, there are certain rules regarding no double jeopardy. The first is that if you have a hung jury, then no punishment came down, so therefore the state can try to prosecute you again. A hung jury means that no verdict was rendered, no disposition was found in that case. Therefore, it's still open, and you're still fair game to be prosecuted again and again and again if it's a hung jury. The state trial must continue to a conclusion. If there's not a guilty verdict, the defendant cannot ever be retried on the instant case except in the result of a federal case. And what I mean by that is that if you're found innocent or not guilty, that's it. You can't be tried on that crime again. However, if there's a related federal crime, you can be prosecuted in federal court. Remember, we have a dual court system in a different way. An example would be in the Rodney King case, the state tried to prove that the officers had assaulted Rodney King and caused some damage. They failed to do that, and they were set free. They were immediately recharged in federal court, and in federal court, they were convicted of violation of civil rights. And so it's the same action that occurred. They beat him with a stick, basically, but the charges were different, and therefore they were able to do that. I want to move on now to the trial process, how it starts. The first thing that happens is there's opening statements. Both sides get to talk to the jury. They get to introduce themselves, talk about what the outline of their case is, lay it out, and develop a relationship with the jury. Now, when they do that, they're able to pretty much say anything they want to say, and it's controlled by the judge, but you'll see a lot of dramatics and a lot of promises on either side to be able to fulfill some sort of obligation to provide a witness who saw something that's going to be material to the case. Many times, the strategy in the opening statement is to win over the jury immediately. Because the prosecution has the burden to prove guilt beyond a reasonable doubt, they get to go first. And they must establish, first of all, that the corpus delicti of the crime occurred. In other words, the elements of the crime, that a crime did occur. Then they have to prove that the defendant committed the crime beyond a reasonable doubt. If they can't do this after the presentation of their part of the case, the defense will move for a directed verdict, asking the judge to basically dismiss the case. Presentation of the prosecution's evidence. Evidence issues. The prosecution will usually look at a variety of things. We use this term FICE, which means fruits of the crime. Fruits of the crime is what was taken. If money was taken and it was found on the defendant, that's good evidence to use. Instrumentality. Let's say that a pry bar was used and it left some striation marks, scratches on a door lock or door jamb. You could compare those under a microscope and match those up. Other types of evidence include direct versus indirect. Direct evidence is somebody saw something occur and you can directly connect somebody. And indirect evidence means that there's an inference that something occurred. It's circumstantial, in other words. If there's a fingerprint left on a glass table, it shows that the person was there. It doesn't show that they were there at the time the offense took place. In other words, there's a burglary. A young man is accused. He's also a friend of the victim's son, and so he can establish an alibi that he's been in the house before, so of course his fingerprints are going to be there. Transfer evidence, which includes fibers from your clothing, if two people make contact, hair to clothing, and also other sorts of chemicals like makeup, etc. Confessional evidence, meaning that the person gives a confession and you are recording that, and we're going to determine whether or not it's valid and it was taken willingly and they didn't violate their rights. And that would be something else we'd look at. And then chain of evidence issues. It's really important that we document chronologically from the point someone found evidence, how they collected it, where they collected it, what time, what day they collected it, what they did with it, who they turned it over to, who booked it into property, who took it to the lab to be tested, who brought it back from the lab, who booked it back into property, and then who picked it up to bring it to court that day. Those things are all important. Also, testimonial evidence. You have what's called lay witnesses, which are basic folks on the street who saw something occur. They have no special expertise. You have the investigations officers that were involved, and those would be the detectives that would have worked on the case, and you would interview them regarding what they know. They're somewhat experts. You have expert witnesses who might testify about DNA, about tire tread marks, about footprints, about blood. They have a special expertise. I had a case where the chemist came in and testified about makeup that was found on the inside of a sleeping bag that was put over a victim's head when she was raped, and it came off of her eyelashes onto the inside of the bag, and we were able to show that she was in that vehicle and that was over her head, that it was the same chemicals in her makeup that were on this bag. Hypnotically enhanced memory or evidence, and it's been a trend for a while to put people in a relaxing state, have them try to bring up evidence that now will give you some leads into the case. The thing is you can't use that hypnotic evidence in court as direct testimony because of the implication that the officer would have put that idea in the hypnotized witness's mind. Okay, scientific evidence, and I already talked about trace evidence, fibers, chemicals, blood, gunshot residue, really important. Tool marks. I use the term striation, and a striation is created when a hard object makes contact with a softer object. And if you have a tool like a pry bar or a screwdriver that's used to pry a lock open, it's going to leave marks. And under a microscope, a pry bar and a screwdriver leave really definitive, individualized marks because they have like a little teeth grooves on the top of where the blade is that you don't normally see with the naked eye. But under a microscope, you can match it up. It'll line up. You have photographic evidence. You have writings where you might be comparing something from one person, how they wrote their signature. document comparisons, DNA, of course, and blood matching. Now, DNA is basically coding the genetics of the person's, body, and blood matching is a little different. You have, type A, B, positive, negative, etc. The problem with blood matching is if the person is not what's called a secretor, then you're not going to be able to match the blood necessarily. If they leave semen, etc., that any of the other fluids may not secrete the blood type. If they leave blood, we can test it. The judge also has to decide if he's going to let the jury visit the crime scene. And of course, it's going to be under his or her supervision, and they might also allow video reenactments of the crime. But of course, those can be really tailored to meet the needs of whoever's producing that video. So what happens with witnesses? I already gave you kind of a list of the type of witnesses you might encounter. They're subpoenaed. They're brought into court. They're basically given an oath of affirmation that says that if you lie, it's perjury and you could be prosecuted. And at that point, they're subjected to examination. Now, the process is, the first step is called direct examination. Topics are identified and discussed. The second step is cross-examination. They can only cross-examine the witness regarding the covered topics from the direct examination. And their attempt is to impeach the testimony to show the person is lying. The next step is redirect, and this is where the original interviewer will try to rehabilitate or make better the testimony after it's been attacked in cross-examination. And then last is recross, which is an attempt to discredit the second time. If you're going to talk about new topics, you would ask the judge to open new direct examination, and you will follow those rules. So it's really controlled what can happen in the courtroom. The attorneys can't just jump off topic. They may even want to bring that witness in as their witness and start with direct examination of them regarding the case. If there are objections to a question, it's brought to the judge's attention, and the judge will either sustain the objection, which means he agrees with the objection and it's got to stop or be stricken. The question must be stricken from the record. Or they can overrule and disagree with the objection, and the question must be answered. There's other things that the judge must deal with, and those are called privileged communications. The one that you hear about the most, well, there's a couple, but husband and wife, except when a member of the house is a victim of violence, a husband or wife cannot be forced to testify against each other. If the wife is the victim of domestic violence, then that's a whole different story. Clergy confessor, if you go to your priest and confess, they can't be forced to testify against you. Doctor patient, the doctor has to report any crime activity, but as far as medical information, that's confidential. Lawyer client, of course, you already know about. Let's talk about some defense strategies. The first, of course, is after the prosecution has finished delivering their case. If there's nothing there, they're going to ask for a motion for directed verdict. And the judge can find the defendant not guilty, or reduce a crime to a lesser but included crime, or deny the motion and order the trial to continue. Or they can request that the defendant is not guilty by the evidence, and this can be done when the state only has circumstantial evidence that's weak. Other strategies include an affirmative defense. In an affirmative defense, you basically are saying that, okay, I did what you said I did, but it's with legal justification. And if you read, I would like you to go online and find PC 26, or go to a penal code section. You're going to have to go do the research on this. PC 26 are the defenses, and some of the defenses where you can have legal justification for committing a crime include self-defense, insanity, accident, misfortune, entrapment, acting under duress or threat, unconscious act, and I believe there's also one called necessity. And in necessity, that means that you basically were driving around in Tahoe and your car crashed, and you had to break into a place to give first aid to someone who needed it. And so you broke into a cabin that was there. The next thing that happens after the prosecution runs their case, the defense gets a chance to respond with their case, and then the judge gives instructions to the jury. Things that will be covered will be what corpus delicti for that crime is, so they make a determination whether they feel the crime was committed and the defendant did it. Laws that apply to the situation related to the defense theory offered. They'll clarify any legal language or questions that the jury might have, and this is done in full view of the other two attorneys that are representing the case. As a matter of fact, anytime the jurors have a question, they're brought back in to the courtroom. Other topics to be covered could include expert witnesses, and they'll discuss the term beyond a reasonable doubt. At that point, they charge the jury, send them into deliberation, and in deliberation in private, they discuss the case, they render a verdict, they return to court to hear testimony read back if they need to. They view evidence again, they ask the judge any questions they may have, and they may be sequestered to prevent misconduct if it's going to be a long decision-making process. Once they come back in and they render a verdict, the jury may be polled, and each of them is asked how they voted. It takes a unanimous decision in California to get a guilty verdict. After this is rendered, this is the last opportunity for another motion for directed verdict. Even after a guilty verdict, the defendant may make this motion. The defendant is claiming that the jury made an error in law by finding him guilty, or they raise some other ruling. One of the things that might happen is during the polling process, they may see that one juror is extremely reluctant, or more than one was reluctant to state that they had found somebody guilty, and that might be basically a basis for appeal. Okay, so we've taken you through the basic trial process here in Lecture 8. I want you to check your exam schedule, your homework, Dropbox, and discussion activities to see if there's anything related to this lecture. Please make sure that you turn in all of your work on time and keep up with the reading. Thank you very much.